You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 62. Should I file a request for continued examination? My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Or if it's too hard to remember, you can get to it through patentingforinventors.com. That's patentingforinventors.com, or call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state. So feel free to contact me regardless of where you live. In the last episode, I talked about 8 options for what to do if you get a final rejection. In this episode, I'm going to talk about one of those options called a request for continued examination. Remember that final office action doesn't mean that your options for getting a patent are over. The patent office may say final, but like in The Princess Bride, I do not think it means what you think it means. Final does not mean final, and in this case, if you want to do a request for continued examination, all final means, in this case, is that the patent office wants more money from you. So, how much money do they want from you? It depends on what size entity you are, and if it's your first request for continued examination, or you're on your second or higher request for continued examination. Currently, a first request for continued examination costs $1,300 for large businesses, $650 for small businesses, and $325 for micro entities, which are usually individual inventors that don't have a high income. If you happen to do a second request for continued examination, the cost goes up, and it's $1,900 for a large business, $950 for small business, and $475 for micro entities. If you do more than 2 RCEs, then the fees are the same as the second RCE, but always check the patent office for the latest fees. When you get your final office action, you'll see something that says how much time you have to respond. It's almost always 3 months if you don't want to pay any late fees, which are called extension fees, and up to 3 extra months if you want to pay extension fees. The extension fees can be as little as $50 for a micro entity for just 1 month, or as high as $1,400 for a large entity for a 3-month extension fee. There are amounts in the middle depending on how many months and how large your entity is. If you don't remember entities, go back and listen to episode 26 about how to get reduced patent filing fees. If you miss the deadlines, your application goes abandoned. You can revive it for even more money, which we'll get to later, but you don't want to get to abandonment stage if we can avoid it. So what do we put into a request for continued examination? Technically, there's a form that you can fill out, and it's form PTO SB30, which you can find on the Patent Office website. You'll check boxes about what documents are in your filing and what fees you're paying, but I haven't found that it's actually required. When you upload your response to the office, you can select that your response is a request for continued examination, and the rest of your response is like responding to a non-final office action. You have to address all the issues that the examiner brought up in the final office action. Maybe if your first office action, you made some amendments and you made some arguments, and now the examiner is rejecting the amended claims. So what you'll want to do is either amend the claims, argue that your amended claims are allowable, or don't amend the claims and say the examiner is wrong to reject your amended claims for the reasons that you put forth. There's no magic formula for getting an allowance. There are no magic words. It really depends on the facts of your invention, what's already out there that the examiner is using as the basis for the rejection. Now, if you made arguments in the first office action and the examiner just didn't buy it, the odds are if you just do a request for a continued examination and make exactly the same arguments without changing anything like amending the claims or finding a different way to convince the examiner that rejection was improper, then you're probably not likely going to convince the examiner for an allowance. So it's best to do something different from how you responded in your first office action response. You format the response the way that you did in the response to the first office action, and after you submit it, it takes usually a couple months until the examiner gets to it and writes another office action. Usually once you file an RCE, the next office action is supposed to be a non-final office action, so you get 2 bites of the apple again when you file an RCE. But it does happen sometimes, especially if you haven't made any new arguments or amendments, that your first office action after the RCE will be another final office action. And then you'll have to go back and decide which of the 8 options that I talked about previously you want to do at this point. But hopefully, after you filed an RCE, the next thing that you hear back from the examiner is an allowance. Now, on average, for a patent to be allowed, it takes more than 2 office actions. So what that means is, on average, a request for continued examination is filed before a patent is allowed. There are all sorts of variables that can affect this: the art group, the actual examiner, if you do an interview, and other things. But just know, if you've gotten a final rejection, that's typical. It's nothing to get freaked out about as being abnormal or that your invention is especially non-inventive. It's probably just doing the regular course that the typical patent application goes through. Now, there are things to do that reduce the chances of a rejection, and we'll get to some of those later. But for now, we've just covered the basics of filing a request for continued examination. If you want help with your patent application, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.